Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons have any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated.
Good morning.
Welcome to the United States Court of Appeals for the Fourth Circuit. We have three cases on for argument this morning. First up is 24-0141 Skyline Tower Painting versus Goldberg. And let me just explain what we're going to do in terms of the order of the arguments. Mr. Prather, you will go first. Mr. McCarron, you'll follow. Ms. Green, you'll go third. Mr. Richardson, then we'll hear from you, and then we'll hear rebuttal from the two lawyers representing the petitioners. So that's what we're going to do. I understand, Mr. Richardson, from the clerk that you had indicated that you might want to seek additional time. I can tell you we're not going to agree to that. So you can ask, but the answer is no.
I appreciate it.
Thank you. Mr. Prather.
Good morning, Your Honors, and may it please the court. My name is Roy Prather, and I represent the defendant, Television Tower, Inc., joined by my colleague, Colin Gannon, in this appeal of the district court's remand decision under the Class Action Fairness Act, specifically the local controversy exception.
Was it Mr. Prather?
Yes, Your Honor.
I apologize for not pronouncing your name correct.
No worries. The district court's decision was erroneous and should be reversed because it failed to properly apply the significant basis and significant relief prongs of the local controversy exception under the Class Action Fairness Act. Initially, the Class Action Fairness Act and its purpose requires that generally when there is a class action that involves both a local and an out-of-state defendant, jurisdiction should lie with a federal court. There is no dispute in this case that the defendants, when they removed the case from state court to federal court, satisfied those requirements in that there was a one defendant Skyline Tower painting that was out of state. It's a Colorado company, also based in Nebraska, and the other defendant, Television Tower, Inc., is based in Maryland. Additionally, the case involved a mountain controversy greater than $5 million, and the other requirements were satisfied. However, the plaintiff sought to remand the case to state court under the local controversy exception. I'm not going to walk through each of those factors because there are really two critical ones that I think require the court's attention here and really inform the nature of the appeal that was made. There's one other factor that also is involved, but my friend from Skyline will be taking that on during his time. With respect to the substantial basis or significant basis prong, that requires that the local defendant be a significant defendant for purposes of the conduct that's the basis of the claims that are at issue and the relief that's sought by the plaintiffs. In this instance, Television Tower, Inc., the local defendant in this case, was the party that owned the property that the tower that was work was performed on by Skyline Tower Painting that resulted in paint flakes being dispersed throughout the area, as the plaintiffs have alleged. Here, the Skyline was the party that participated in the conduct that actually resulted in the paint flakes being removed from the tower and escaping to the plaintiff's properties that have now been the basis.
Doesn't the local controversy exception contemplate that there can be more than one significant defendant?
It does, Your Honor. And when looking at whether there is more than one significant defendant, the analysis requires a comparative view of what the conduct was of those defendants relative to the other defendants in the case. And in this instance, the conduct that actually forms the harm that's actually underpinning every single claim that's been alleged by the plaintiff is the power washing of the tower that resulted in the paint flakes escaping from the tower and being deposited on, or at least allegedly deposited on, the plaintiff's properties.
Well, that's certainly true that was the, that was the, may have been the final event that resulted in this calamity, but your colleagues on the other side allege other activity. You may disagree whether or not it's significant, and maybe you can tell me whether or not it's sufficient to simply make the allegations, but they allege, among other things, that your clients were negligent or omitted, didn't take particular attention with respect to licensing, that they participated and supervised the activities of the painting company involved in this case. So there are a number of allegations that suggest that this wasn't simply a contractor who stood by and just watched as the activity, the painting and the flaking of the lead took place, but took on activities beyond simply hiring the contractor. First of all, do you agree with those factual predicates? And if they're in fact accurate, is that enough to make your client a significant defendant?
First, Your Honor, no, I do not agree with those underlying factual predicates. And the complaint itself,
why not?
Because the complaint itself, as alleged, doesn't provide those factual predicates either. On the one hand, it states that TTI directed the activities of this specialized contractor to perform this painting work, but at the same time alleges that that specialized contractor does this particular work on these types of towers and is the party expected to understand and know how to perform that activity. I think the Allen v. Boeing case that the parties discussed in their briefing, and that was discussed as well by the district court, is particularly relevant here in the Ninth Circuit. There was a property owner in this instance. That property owner was out of state.
They allege that TTI controlled the manner in which Skyline conducted its hydroblasting work, including acts or omissions that led to the contamination of the. That's pretty broad and encompasses. That's an allegation in their complaint.
Yes, Your Honor, and it's a conclusory allegation that actually isn't supported by any other factual claim within that complaint and is contradicted by the other allegations that they make regarding the steps that Skyline itself took with respect to hydroblasting the tower. The directing of the activity by TTI is more akin to simply needing to hire a contractor to complete painting and then instructing that contractor to, using its expertise, complete the project that's been requested, and not specifying how that's to be completed because TTI does not have the knowledge or expertise for how that is appropriately conducted in the first place, which brings me back to Allen v. Boeing, which in that instance, there was the property owner who contracted with another party to conduct remediation of its own property, and both parties were sued when the contamination that was at the property escaped from the property and contaminated other properties. In that case, the court looked at the conduct specific of those two parties and found that the owner of the property, even though it was the one that owned the property where the contamination originated and actually created pollution itself at that specific property, was not as significant as the activity that resulted in the contamination spreading to other properties. Now, in that case, the local defendant was actually the contractor that spread the contamination. It wasn't the owner, whereas in this instance, the local...
I just want to make sure that I'm switching gears for a second. Is your colleague going to address the 2/3 of... And
yes,
you're
Your
not
Honor.
addressing that? Okay.
Yes, sorry, I wasn't clear on that. Thank you.
Mr. Prather, the sort of the tone and tenor of the allegations with respect to TTI is that your client was negligent in hiring this contractor, and maybe you think that's just a conclusory allegation. There's some allegations that TTI failed to confirm whether or not the contractor was actually licensed to do the work. Is negligent hiring, do you think negligent hiring is enough?
No, Your Honor, I do not. Not when the harm that's alleged is not related specifically to the hiring, but the conduct that occurred subsequent to that hiring. The gist of the allegations that are being made that underlines every single harm and every single potential claim is that there was power washing on the tower that caused the paint flakes to escape from the tower. Now, with respect to comparing the relative conduct of those parties, and this is consistent with the analysis that the court did in Allen v. Boeing, the activity of the contractor, the gist of which was that not simply owning the property that contains the contamination that was spread, not simply even generating at the property itself the potential contamination, was not the primary gravamen of that complaint, but rather the actions that led to it spreading to other properties. The allegations that have been made in the complaint by the plaintiff suggest a similar circumstance here. And additionally, where they don't specify or otherwise differentiate, they attribute all of those activities to the defendants collectively. And similarly, when there are collective allegations being made as to the defendants, that doesn't provide any specificity by which to compare or otherwise determine which of those defendants is significant. And because the Class Action Fairness Act counsels towards maintaining federal court jurisdiction, courts that have encountered that scenario find that that doubt should be found in favor of keeping the matter in federal court.
You've spent most of your time talking about conduct and whether or not conduct alleged is significant enough to implicate both defendants, including your client. Do you have anything to say about the nature of the relief that's requested here? It seems to me that the complaint alleges or makes allegations or requests for relief that equally implicate both defendants. So why isn't that enough, at least with respect to that prong of the analysis?
With respect to that prong, it's similar to the analysis for the significant basis, whereas if the complaint, the out-of-state contractor or defendants, the relief sought there is not more, or is as significant as that sought from the local defendant, that's not a basis of viewing the local defendant as a significant party upon which relief is being sought. Ultimately, whether it's less or equal, that still counsels towards keeping the matter in federal court.
One question. If we agree with you that you have an appeal right, which you're arguing under 1291, does that render it unnecessary for us to reach the question of whether the appeals under 1453?
It does, Your Honor. However, it is still a live question with respect to the availability of appeal under both of those. It's TTI's position that a direct appeal under 1291 is available and appropriate and just provides an alternative means of obtaining an appeal, which would be more expedited under the Class Action Fairness Act statute.
Thank you, Mr.
Thank you, Your
Pritchard.
Honors.
Mr. McCarron?
Good morning, Your Honors. Thomas McCarron on behalf of Appellant, Skyline Tower Painting, Inc. May it please the Court. We ask this Court to reverse the District Court's order remanding this matter to the Circuit Court for Baltimore City and hold that the appellees here, plaintiffs below, did not meet their burden to establish that 2/3 of the proposed class members are Maryland citizens in order to qualify for the local controversy exception to the Class Action Fairness Act, or CAFA, the very purpose of which is to confer broad federal jurisdiction over class actions naming defendants who are not citizens of the forum state, with only narrow exceptions for which the burden is on the parties seeking the remand to establish exist. In so doing, this Court may decide to address certain matters that appear to be matters of first impression in this circuit, at least. First, whether a court, in reviewing a remand motion, may consider materials outside of the pleadings or go on to consider extrinsic evidence such as was submitted and considered by the District Court here.
Can I ask you about, with respect to this issue, I mean, this isn't a case where there is simply an allegation with respect to citizenship and the plaintiff stands on those allegations, there was at least an effort to try to present some evidence in support of that allegation. What else do you think the plaintiffs or the petitioners in this case were required to do?
Well, first of all, I would note that in sort of discussing Fourth Circuit lack of precedent, the district court itself sort of referenced a number of things that aren't present here. License, motor vehicle licensure, and other items that go toward domicile, which is, of course, the test for citizenship relative to an individual, not mere residency. Here, all that was presented to the court below were literally a series of addresses from which the paralegal, the affiant, used an app or two to, first of all, determine that the addresses were within 4,000 feet radius of the tower. We don't know anything about that application. There's no offer of proof as to the reliability of that. Secondly, the list of addresses commingle initially, and then corrected, I think, on reply only as to government bodies, residences, businesses, and government-owned properties. We're not told how many of those are businesses. We are later told with the affidavit on the reply how many were government, government offices or government properties. And I think that may be
so, but at least there was some attempt to distinguish primary residences from businesses and identify whether or not the businesses had their principal place of business in Maryland, whether or not they were organized in Maryland, all to suggest that it would be reasonable to conclude that all of these plaintiffs, whether businesses or at least a significant number of them, enough to get over the 2/3 hump, were in fact, by virtue of having primary residences in this neighborhood and or businesses organized in Maryland with their principal place of business in Maryland, were in fact domiciled in Maryland. Why isn't that a reasonable conclusion to draw from this evidence?
Well, first, as to businesses, what the other side did, in fact, was to identify businesses. Again, we don't know how many in this list are businesses that are listed as having a principal office, quote unquote, in the state of Maryland. That is not to say that that is their principal place of business. As this court has recognized, principal place of business is sort of the nerve center, the headquarters where officers, make decisions.
And that's if the business is a corporation. We don't know of these business, do we? We don't know of the business entities, whether they're corporations or partnerships or
LLCs.
other that might not, in fact, have Maryland qualify as their.
Absolutely correct, and I think that is significantly deficient. And then very quickly, on the just personal residences, we don't know when. I see that my time is up.
No, go ahead, finish your
just
answer.
complete thought. With respect to the residences, we don't know, first of all, when that was declared as principal residence. The key in determining diversity, of course, is when the complaint's filed. We don't know anything about whether or not these are in fact domiciles, which requires an intent to permanently remain, basically.
All right, thank you.
Thank you, Your Honor.
Ms. Simmons?
Good morning, Your Honors, and may it please the Court. Grace Green Simmons for the U.S. Chamber of Commerce. The Chamber appreciates being heard on this jurisdictional issue. This Court should join its sister circuits and hold that remands based on CAFA's exceptions can be appealed as of right under 1291. The baseline rule for remand orders of all kinds is that those remands that can be appealed are appealed as of right under 1291. The remand kicks the parties out of federal court back to state court, ending the federal case. That fits squarely within the definition of a final order. Now, 1447D bars certain remand appeals, but not those based on grounds external to the removal process.
That's a Supreme Court rule, and we have to agree with the Supreme Court on that, but if you read that 1447, it looks pretty clear to me. It's much broader than what they say, but we are limited to the narrowness of the Supreme Court's determination.
That's correct, Your Honor. In Thermtron in 1947, the Supreme Court read 1447D's bar in connection with 1447C's two categories. And so, as the Supreme Court has reaffirmed several times since, that bar on appeal has to be limited to remands based on lack of subject matter jurisdiction and procedural defects in the removal itself.
So your whole contention is that if it's not under C as one of those grounds for D, that then you have an appeal right that exists under 1291.
Yes, Your Honor, and the courts of appeals have recognized that, the Supreme Court has recognized that. There's a number of grounds for remand that fall outside those two categories. Abstention is a big one. Others include form selection clauses in contracts that say you have to be in state court, not federal court. There's doctrines like waiver by participation in the state court. These are all grounds that are external to that removal process and so don't fit within C and so aren't barred by D.
You're not expressing opinion on the merits then?
No.
You're here to tell us that we can take this appeal.
Yes, Your Honor. The Chamber takes no positions on the merits of the local controversy issue before the court. Our sole ask is that this court hold that appeals like the ones at issue here can be brought through 1291 rather than having to go through 1453C's permissive appellate procedure.
Is there well, I guess you're not taking a position in this case, but would it matter? I mean, is there a concern about whether or not if we don't agree with you in this case, that it might have implications in future cases? Because it seems the argument here is that whether 1291 or the other subsection applies, they satisfied both in this case. And of course, I don't ask you to take a position there, but what's the significance of ruling that 1291 applies in this case for future cases?
The benefit of doing so, Your Honor, is to provide much needed guidance and to make this process more efficient for litigants in this circuit, including this court, and that's exactly what the Fifth Circuit recognized in Cheapside when it was faced with a near identical situation. There, the Fifth Circuit had actually already granted the 1453 petition, and yet still had the parties brief jurisdiction under 1291, and then went on to hold and make clear that they could have just proceeded through 1291, and the Fifth Circuit explained that it was doing so as to make that process more efficient for everyone.
Do you have anything else?
If the court has no further questions, we thank the court for its time.
Thank you very much. Mr. Richardson.
Good morning.
Morning.
Good morning. Ronald Richardson on behalf of the appellees. And I'm going to start with the 1291 issue because that was last argued. CAFA has its own appealable statute, 1453. There's no need for 1291. In fact, 1291 has no purpose under CAFA. It's a final judgment statute on the merits. The case law says that for purposes of 1291, you have to have a final judgment on the merits. Remand orders have nothing to do with anything on the merits. So for that reason, 1291 is inapplicable here. And as was pointed out earlier, there's a 1453 petition that was filed in this case. And I want to go to that very quickly.
So you don't think you can do it both ways?
I don't think you can. One's not designed for that. It was never intended for that. It has no purpose for that. And it has its own statute, which is very, very important, specifically for the facts of this case. And I will go into that right now. In this case, the appellants petitioned this court on March the 11th of 2024. Judge Rubin entered her order on March the 10th of 2024. That is 11 days that they filed their petition. The rule 1443C says you got to do it within 10 days. And that's very important because the Murdoch case as held, Fourth Circuit, that this whole issue of the petition 1443 is jurisdictional. And the Bowles Supreme Court case has held that the timeliness of the filing of your petition is critical, because if you don't meet it, there's no jurisdiction on the appellate, on the federal appellate level.
Wasn't there a note that the order was entered on March 11th, 2024?
I'm sorry, 2024, no, it was, you're right, Your Honor, but here's what's,
So there was a note that the order was, I mean, the docket says it was filed March 10th, but then there's a note that says it was entered March 11th. Does that matter?
it does matter.
To your argument?
It does, well, and here's, so, Local Rule 102.5A says that the electronic filing of any document, including an order by a judge, constitutes the entry of that document. And so she electronically filed it on the 10th. And Federal Rule of Civil Procedure 77A says every district court's open every day, any day. Federal Rule of Civil Procedure 6, you don't exclude any days. And Federal Rule of Civil Procedure 77D2 says that you can't claim lack of notice. The district court entered its remand order on March the 10th, which is confirmed by an entry on March the 11th, but it was entered on March the 10th.
And that's based on the rule that you just read?
That's right. So
Okay.
that's when it became effective. And you can't claim that you didn't know, you can't claim it was on a Sunday. So that starts the day. So you count 10 days, they should have filed it by March the 20th. And they filed it on March the 21st. Ergo,
But she signed it on March the 10th, but it wasn't actually filed until March the 11th.
no, it was entered on March the 10th.
Filed on the docket. If you look at the record in terms of when it was actually filed on the docket, it looks like to me it's March the 11th.
I believe it's March the 10th, Your Honor. And if it's March the 10th, they're late. And I'll raise that only for the purpose of establishing that we may have an issue of whether or not the appellate court has jurisdiction. And I will leave that for your honors to decide from there.
But to be clear, the 58C does say that it is effective when it's actually electronically filed. The docket, you agree with that, don't you?
And filed happened on this case
So
on
it's
the 10th.
not a question of if the record does show she signed it on one day, but it was actually filed on a different date, it's the filing date that controls, is that right?
If you, that's correct.
If that's the record.
That's correct. And if you look at the docket, it says the 10th. And so I think that they're late. This court should stay in state court. I mean, this case should stay in state court. This is truly a local controversy, if ever there was one. The defendant, the tower is in Baltimore City. All of the affected properties are in Baltimore City. The legal issues.
But are 2/3 of the class members citizens of Maryland? Have you provided, I think that's, at least that's the question I have.
Okay.
Have you provided sufficient evidence to support that? And for me, how is it that we know that any of the owners on that chart ever had an intent to remain in Maryland?
So, in their removal to federal court, the appellants concede the following on paragraph 11. Plaintiffs are residents of Baltimore City and own property in Baltimore City. One's place of permanent residence is generally also the place of domicile, absent additional facts demonstrating an intent to do otherwise. And they cite the Bainham case, which says, explaining a person's domicile is the place where they have true, fixed, permanent home without any present intention of removing therefrom, and to which place he has, whenever he is absent, an intention of returning. They cite that in their notice of removal.
Right, because that's the law. That's domicile equals residence plus intent, and I'm trying to understand how the chart
Oh, I
that
see.
Affiant made equals residence plus intent to remain. Perhaps it equals residence,
So,
I don't know. But how does it equal intent to remain?
so on the chart, there's a column all the way to the right that's either yes or no.
Uh-huh.
And Ms. Greeley, in performing this function of creating this chart, if she could not determine by absolute certainty that it was their primary residence on the chart,
How did she know by an absolute certainty that it was her primary residence? Did she call him and ask him?
no, when you go to the SDAT website into that tool, it has primary residence section right there. And it tells you yes or no on that, and it tells you if that's a primary residence or not. So she was able to determine, based on the research tool that was available to her.
Okay, so based on primary residence, you're saying that primary residence equates to intent to remain?
Yes.
Okay, so where in the record can I find what tax year it was that the applicant considered in evaluating the principal residence? What tax year did she
She looked
look at?
at the time that she did the affidavit, she looked at those websites.
When was that then?
I mean, I'm sorry, yes, that was back in, we filed the remand motion, I want to say early, go ahead.
Go ahead.
No, it was, Judge Rubin had that remand order for a year. So I think we filed it sometime in '23. She issued her ruling in '24. And we're now in '25.
So she looked at tax year 23
Yes,
or 22?
I believe it's '23, because she did not do it at the time that the incident occurred, which was '22. She certainly didn't do it then, because we didn't even file the lawsuit until after.
But how do we know that, if she did it in 23, all right, go
Right.
ahead. It's confusing to me as to what tax year
So,
was even looked at. So then can I ask you a question about the businesses? I know that her method for the corporations was to see if, I guess, if they had their principal office in
yes,
Maryland?
and she took care not to make sure they weren't LLCs or some other type
How
of.
do we know that? So all of these, so you're saying that all of the businesses on this chart are corporations and not some other business entity?
Are either corporations or LLCs, but Ms. Greeley determined that under either scenario, if their principal place of business was located in Maryland, she put a yes. If she could not make that determination at all, she just erred on the side of caution and put a no. But I will tell this court, because I can proffer to the court, there's 550 businesses on that list. There's 70 government-owned properties on that list. There's 234 individuals on that list that have been registered as no. You add them up, it's 854. You do the math, that's 69%. That's even if you exclude them all, that you still meet that burden. So I do not think it's, and it's all about practicality and reasonableness, and Judge Rubin really did, in my humble opinion.
So you're saying if there isn't sufficient basis for any of the businesses, if we took them all out, the numbers still add up to more than 2/3?
That's correct.
And then we'd still have the intent to remain, or
That's
I
correct.
might still have the intent to remain issue to sort out.
Well, let me ask about that, because that's a good point, and, but as I understand the law, or at least the law that you want us to apply in this case, because CAFA, the court's decision whether or not to accept, keep control of the case is not a jurisdictional issue, then this two-prong requirement of residence plus intent to remain doesn't necessarily apply in this context. You can simply rely, at least according to some cases, on a presumption that residence equals domicile, and
That's
that's what
correct.
you're arguing in this case, right?
That's correct. And I apologize, Your Honor.
No, go ahead.
So it's rebuttable, though. So.
Sure, right.
But did they provide any evidence at all? They've had all this time. The court has no evidence from the appellants as to anything to rebut the evidence that we provided to the court. And the case law says that, that's Mason, the case particularly. When you do that, the court can then find, under his or her discretion, that that standard has been met. There's no evidence to rebut it. Finally, I just want to sum up by saying we have sued them all for the same damages, practically the same counts, except for TTI, where we sued for negligent hiring, retention, and supervision. And the claims that we have, the allegations that we have against TTI are significant. I thought our brief fairly laid them all out, and so
Well,
I
your
won't go
colleagues
over
on
them.
the other side complained that they're just conclusions, there are no facts to support the conduct or alleged conduct. Why don't you tick through what you think are the
Sure.
significant things that TTI did or didn't do which hooks them into this case?
Absolutely. First of all, TTI is the owner of the tower. TTI knew, there's no evidence Skyline knew, but TTI knew that there were 2.5 tons of lead-based paint on that tower, and they knew it since the 1980s. All of that's in the complaint.
Now, we're talking about conduct, right? Are you saying that that's conduct?
Well, all of it goes towards the conduct, which is like they hired them. They hired them to hydroblast, and they knew it was lead-based paint. They hired them to hydroblast. They could have hired them to scrape it off. They hired them to hydroblast it.
So
They-
you're-
they-
you-
I'm
so-
sorry.
I'm sorry. So you're alleging that that decision to hydroblast as opposed to scraping is misconduct on their part?
If you know that what you're hydroblasting off is lead-based paint, that is a tremendous health risk to the community right under that tower, who have a park, a community park, Rock Rose Park. Kids play in the playground there. There's the significance of that decision to make them hydroblast as opposed to scrape is critical, and that's why we asked for punitive damages, because they knew better.
And how do we know that TTI made that decision as opposed to the contractor?
Because there's no evidence the contractor had any knowledge that there was any paint on that structure. There's no evidence of that. We haven't done any discovery yet. This is all complaint-based. But what we do know is that TTI told the community association that they knew it was lead-based paint since the 1980s. And so what we do know is they hired them to hydroblast. We haven't seen the contract yet. This is all going to be in discovery. But our allegations at this point says that they knew this, which is very, very important conduct. We have sued them for strict liability, for several, joint and several liability. And when you do that, the case law has said that that's a significant, you can find both, because there's more than one can be significant, both to be significant for purposes of this particular element. And I can go on the list because they didn't do anything to make sure that this contractor was properly accredited. And it is incumbent upon the general contractor here to do that when you know what you're doing is essentially a lead abatement process that's not handled properly. And they control the manner in which how they perform the work. So I say all that to say that there's no question that TTI is a significant player in this, and that it's a party, a defendant, a local defendant, in which there has been, from which significant relief is being sought. And so I think that we have met that burden. I think the court found that we had met that burden. We met the burden for a significant basis, and I think the court also found that. And the court reasoned that it would be completely unworkable to go through 2,785 putative class members and find out specific details as to each. You don't need to do that, especially when you have the presumption. And
Is that burdened by preponderance of the evidence?
it is. It's their burden or our burden?
Your burden.
Preponderance of the evidence.
And is that established within this circuit, or is it something we have to decide?
No, I believe that's established, but there is case law that has said that it's by preponderance of the evidence. I don't have it at the tip of my tongue, but I believe there is case law that says that. But if not, I'm sure you'll let me know.
When was the complaint filed? What was the date of the complaint?
I have those notes, Judge Thacker, but I don't remember. It was filed about a week or two after the Maryland Department of the Environment filed theirs, but it was in,
2022?
yes.
Okay. Well, then, does this chart include people that own property after the complaint was filed? I think the complaint was filed May 8th, 2022.
Yes.
Does the chart, you
Yes.
said she looked at tax year
Yes.
2023, so doesn't the citizenship have to be established at the time the complaint was filed? How do we know that these people lived, that are on the chart, lived there
So-
at the time the complaint was filed, since she looked at tax year 20, you said
So they,
2023?
so they are still removing paint chips from the tower. It has not stopped. There is continuation of debris, lead paint chips falling on that community to this very day. So to the extent that people have moved or have sold or have bought property afterwards, they're all putative class members because their properties are still being contaminated. I don't think it really matters whether or not it was a particular day that she did her analysis, because it's an ongoing thing, the putative class members. But the point of the matter is that way more than 2/3 of them are citizens of the state of Maryland, and we meet that prong for that reason. And so I think that this, like I said at the very beginning, this is truly a local controversy. And the whole purpose of the exception is that if it's national importance or if it's interstate commerce, it goes to federal court. But if it's a truly local controversy, then it should stay in. And that's why Congress created the local controversy exception, is because there may be instances where cases belong in state court. We respectfully submit this is one of them.
All right, thank you, Mr. Richardson.
Thank you very much.
Mr. Prather?
Thank you, Your Honors. I'll be quick. Two key points. With respect to this timeliness issue that counsel for the plaintiffs raised, I would direct the court to JA6 in the joint appendix, which is a copy of the docket, and specifically 23 and 24, those entries that provide the memorandum opinion of the judge and the order, which specifically notes that it was entered March 11th, 2024. And additionally, in the briefing and the discussion that the parties had in their briefing, note that the ECF email that notified the parties of that order was also received on March 11th, 2024. And so the idea that March 10th would be the appropriate time to expect the parties to respond within 10 days when they had no knowledge of that order on March 10th just is not consistent with what the rule requires, and it's not consistent with the practicalities of an order being signed on one day and entered on another. With respect to the claims that were made in the argument regarding the conduct, again, I would point the judges to this concept of group pleading that the plaintiffs did throughout their complaint, which essentially claimed that, contrary to what we just heard, both TTI and Skyline knew that there was lead-based paint on the tower. The complaint actually makes that allegation in multiple of the claims that were alleged. And again, if you look to the kitchen case that that TTI cited in relation to the Eighth Circuit's analysis of that significant or substantial basis element, when you have allegations that allege equal conduct or shared activity among those parties, that's insufficient to, comparatively speaking, point to one particular defendant as being more significant than the other, here in particular as it pertains to the conduct of TTI.
Do they have to, does one have to be more significant than the other, or can there be more than one significant party? We talked about that earlier.
The local defendant needs to be more significant because that is the anchor by which the court will decide to treat it as a purely local controversy under that exception. So comparing the conduct of that local defendant or the local defendants to the out-of-state defendants, the local defendant needs to stand out in terms of its conduct relative to those out-of-state defendants. And that's key because going back to one of the circumstances that was just previously identified, which is interstate commerce, we have a circumstance here where the commerce was the transaction between the local defendant, TTI, and Skyline, a Colorado company, to conduct that painting work at its tower, and that painting work became the basis for the complaint and the claims that have been alleged. When you have that circumstance, that is a situation where the Class Action Fairness Act counsels that those litigations should proceed in federal court.
Can I ask you about the difference between significant and primary in the statute? So there's D4A talks about the most significant defendant, D4B talks about the primary defendant. That would seem to suggest that significant doesn't necessarily equate to the distinction that you just made about being most significant.
Well, So it does in the sense that as the court looks at significance, it's not so much that there is one defendant that is primary, but that defendant relative to the other defendants has a more substantial role. I believe in the Kaufman case it was its conduct underlies or relates to all of the claims that have been asserted. And here, the conduct that does that is the power washing of the tower that's been alleged by Skyline.
Okay,
Thank you, Your Honor.
thank you. Thank you, Mr. Prather. Mr. McCarron?
Just a few quick points, Your Honor. First of all, on the burden of proof, I think Judge Wynn asked about that. There, in fact, is a split of authority. The Fifth Circuit, for instance, in the Arbuckle Mountain case cited in the briefing, used a reasonable certainty test, which is a more enhanced burden of proof, in keeping there with the notion that CAFA's intent is to extend broad federal jurisdiction and the exceptions are to be narrow. Here, district court in several instances used she used a preponderance of the evidence standard. So if this court concludes that the proper standard is the reasonable certainty standard, on that ground alone, the underlying decision should be reversed.
Nobody else has done that.
That's true. The Fifth Circuit does stand alone.
That alludes to this, that nobody's done that, so why would we do that?
Well, again, I think it's more in keeping with the notion that the exceptions are to be construed narrowly in keeping with congressional intent. But I will pivot to say, whether we use a preponderance of the evidence standard or a reasonable certainty standard, where there is confusion about the citizenship of the putative class, there can be no preponderance of the evidence or much less reasonable certainty. On the affidavit and the spreadsheet did include and continued throughout the district court's analysis businesses. They included government.
Says even if we, opposing counsel says, even if we take out all the businesses, we can do the math and see that it still meets the 2/3 number.
That's not possible because I don't know nobody knows how many of those addresses are business addresses. We're never told. So therefore, we don't know how much you deduct and whether or not it gets them beyond or below the threshold.
If they do need to show residence plus intent to remain, what else would, how are they
Supposed to do that?
What do they need to do?
Well, again, the district court itself mentioned that the Fourth Circuit had not reached conclusions about what is sufficient, and then rattles off about 3 things that are missing here. A licensure of individuals to determine where they intend, where they vote.
All of those things you said when you first got up here.
Yes.
Uh-huh.
I see that.
Well, so I guess the first question we would need to decide is whether or not residence alone is sufficient to establish a presumption, in which case you would have to come forward with evidence to contradict or rebut that presumption. You probably disagree with that test, but if that's the test that we applied, you still win?
Yes, because again, we don't know how many of these are residences or businesses. I don't know how many there are. Nobody does. We're not told. So whatever the proof may be of whatever we assume about residences, we don't know how many in the spreadsheet list are residences. That's the problem.
And why would you argue that we shouldn't make the presumption that residence alone is sufficient?
Well, in a broader sense, not so much in this case, because I don't think you can make any presumptions in this case, given the nature of the proof. In the Evans case, for instance, again, in keeping with a more restrictive approach, because that's what the exceptions are supposed to be, the Evans determination was that mere residency did not establish or give rise to a presumption of citizenship, because citizenship means so much more. Even in the Russo case, the case I would probably guess that the court below most notably relied on, I would say, a trial court level case. There they were dealing with records of owner-occupied taxes, wherein the court took pains to say that the owners had to submit affidavits, giving an intent that they live there with some permanency. So that's absent here. So even the Russo case presents more than was presented here.
That's a district court case,
It-
though, right?
It is, but it's the one that this district court seemed to predominantly rely upon. And of course, we're here at a higher level. We understand that.
Thank you, Mr. McCarron.
Thank you, Your Honor.
I want to thank the lawyers for their fine arguments this morning. We'll come down, greet you, and move on to our second case. Please be seated. Our second case is 24-4114, United States versus Jackson. Mr. Macbeth.
Good morning, Your Honors. My name is Cullen Macbeth, and I represent the appellant, Brandon Jackson. Your Honors, Mr. Jackson was indicted in Arizona State Court after police searched the trunk of his car and found a gun that belonged to his passenger. There was no allegation that Mr. Jackson engaged in any violent or threatening conduct with the firearm. And in fact, 2 separate judges in Arizona State Court conducted individualized, evidence-based dangerousness assessments and concluded that Mr. Jackson was not dangerous and did not pose a threat to other people. They even determined that he could be released pre-trial without imposing a no firearms condition on him. Mr. Jackson's passenger, to whom the gun belonged, later pled guilty to possessing it. Mr. Jackson did not, as it was not his gun. Indeed, the weapons charge against
Your
Mr.
challenge here is as applied,
Correct, Your Honor.
but particularly when your client was put in this position, having this gun, he was under the indictment at the time.
When he traveled from Arizona to Maryland, yes, he was under indictment at that time.
So none of the conduct that you, or at least the consequences of what happened, were in play at that time. They had not been dismissed.
No, Your Honor, and
Indictment, so squarely he fits within the statute.
correct. We're not saying he's
Violated the statute in that way. You're saying that there are measures here that exist as to him, why it should not be applied to him. What in particular are you relying upon, and why should we take that route in light of the way we've treated the 922G determinations of this sort? We've looked at it more categorically than we have going on a case-by-case basis. Maybe we're trying to reduce our workload or whatever, but at the end of the day, if you put him in a category, he's under indictment, he fits there clearly, it falls back into facial analysis, and we just haven't ventured there too much, and not too many other circuits. Well, I don't know if any circuits have gone there to apply it in that way, but maybe you can tell me they have been.
So first of all, Your Honor, yes, we agree that Mr. Jackson's covered by the text of the statute. There's no dispute about that. The question is whether it's constitutional to apply it to him. As to the question of sort of categorical facial judgments, I assume you're referring to the Hunt opinion, and
Absolutely.
and we think Hunt is inapplicable for several reasons. So Hunt had essentially 3 rationales to it, none of which we think is applicable to 922N. The first was that at step 1 of Bruin, the Second Amendment protects only, quote, law-abiding people. And we think that a grand jury indictment is not a sufficient basis to determine who is and is not law-abiding. Law-abiding can't just mean anybody who has ever broken any law at any time in the past, because if it's that broad, then absolutely nobody is law-abiding. So there has to be some limiting principle to what law-abiding means, and we think a grand jury indictment is not a sufficient basis to draw that distinction for a number of reasons. First of all, it's a non-adversarial process. So defendants do not get a chance to appear in front of a grand jury. They can't cross-examine the government's witnesses. They can't present their own evidence. The rules of evidence do not apply, so grand jurors can consider hearsay, propensity evidence, other evidence that is irrelevant or prejudicial. The exclusionary rule does not apply. The standard of proof is just probable cause, which is lower even than preponderance of the evidence. And a unanimous vote is not required to return a true bill. So, you know, we've all heard the famous expression that a grand jury would indict a ham sandwich if a prosecutor asked it to, and that's because it's a very, very, very minimal showing that is required to get an indictment. And it's really not much more than the fact that the police have arrested somebody. Grand juries tend to indict when prosecutors ask them to. So I acknowledge the sort of law-abiding language from Hunt, but I don't think that can sweep in absolutely everybody who has ever supposedly broken the law, and there has to be that dividing line. The second rationale of Hunt.
But on that point, the indictment is temporary.
Correct. It's correct. But the reason that this is unlike other, the courts, including the Supreme Court, have said that other constitutional rights can be burdened to some extent during the indictment period. Like, obviously, people can be detained, it doesn't violate due process. But the difference in this case,
So basically, he could be detained under the indictment alone, for which he would not be permitted to have a gun, but you are saying to give him the lesser option of, we're gonna let you go free, but the statute says you can't have a gun. You don't like that.
well, so I think I take it you're referring to the pretrial detention analog or
I'm
tradition.
skipping ahead of that, because I think we're eventually gonna get there to that.
Okay. So just on the point about other rights, the difference, and the Ninth Circuit makes this point in the Perez-Garcia case, which we cite, is that if you deem somebody non-law-abiding at Bruin Step 1, that doesn't simply mean the government can limit those people's rights to the Second Amendment. It means they can categorically deny them all Second Amendment rights whatsoever. Because under Hunt, if you're if you are non-law-abiding, you're out entirely. You lose all rights under the Second Amendment. And so the government is entitled not just to sort of, impose reasonable restrictions on a right, but to actually completely strip you of all rights. So I think it is different from the way that an indictment is used to limit other constitutional rights in the indictment period.
Does it matter that unlike Hunt, which dealt with the right of felons to bear and keep arms, that this is an indictment which is a temporary restriction on, presumably, on someone's ability to bear arms?
So it would matter if, there's some analog that is similar to that, in that it imposed a temporary disarmament. The absolute burden, I don't think, is relevant. Whether that might have been relevant in the old means and scrutiny system, where we're sort of measuring how severe a burden it is and balancing that against public safety interests. But now the temporary nature of the deprivation is necessary only to the extent that that makes it similar to some other analog. Now, the government has cited pretrial detention and surety statutes, both of which did involve temporary disarmaments, but those analogs are very different in very fundamental ways. So in both of those cases, with both surety statutes and pretrial detention, there was an individualized, evidence-based, adversarial determination that a particular person was actually dangerous and needed to be disarmed. We don't have that with 922N. In fact, 922N disarms all indictees across the board without any individualized process as to their dangerousness. And in fact, in this case, as I said earlier, we actually have an individualized determination that goes the other way. 2 separate judges in Arizona did an individualized, adversarial, evidence-based assessment, and they both concluded that Mr. Jackson was not dangerous and that he could be released without restricting his access to firearms. And I think there is no analog for something like that. There's no historical analog that says when a judge, a neutral judge, has determined that you are not dangerous based on an adversarial proceeding, we nonetheless can take away your firearms. There's just nothing like that.
Did the district court consider, or at least determine whether or not those determinations which were made in other contexts, right, should apply in this case?
The district court really did not address our as-applied challenge in much detail. The court did what is almost entirely a facial analysis and then sort of said at the end, very briefly, I also reject the as-applied analysis, and I find it irrelevant that the charges were eventually dismissed. And to Judge Wynn's point earlier, I think strictly as a legal matter, it is irrelevant that the charges were later dismissed. But the reason I cite that fact...
So the district court said it was irrelevant that the charges were dismissed, but did the district court specifically address the fact that he'd been released on his own recognizance and did not have his firearm?
No, Your Honor, the court did not address that fact. That fact was in our pleadings. I believe I mentioned it at the evidentiary hearing. The court didn't say anything about that fact. Again, the fact that the charges were dismissed, I take Judge Wynn's point that that's irrelevant to whether he was in fact under indictment when he traveled here. But the reason I highlight that fact is that I think it's really good evidence of just how unreliable grand juries are. The state in Arizona later determined that that was not Mr. Jackson's weapon, and they therefore dismissed the charge. Nevertheless, he was under indictment because a grand jury will indict through a non-adversarial process under a lot of circumstances.
So we could undertake this, what looks like me a felon by felon litigation. Hunt said that it was a felony in possession. We won't do that. We won't do the felony by felony litigation. And there are felonies that are non-violent. And yet Hunt said in the context of 922G, we don't do that. Why should it be different here? I mean, why should we now go felony by felony to determine whether that applies here? It did it in a categorical fashion.
So I think the starting point is this sort of dangerousness principle that Hunt articulates has to have some kind of limiting principle. Just like the law-abiding principle has to have a stopping point, there must be some limiting principle. It cannot be that Congress can simply deem any category of people it wants to be dangerous, and then this court will just defer to that.
The limiting principle here, at least as Judge Diaz alluded to, is that this is a temporary situation here. It's not, whereas in Hunt, if you have a felon in possession of a non-violent felony, we said that's okay. And so it seems like to me this is far more limiting than we had in Hunt.
So the length of the deprivation is shorter, but I don't think that bears on the initial judgment of whether a category is dangerous or not. That judgment, whether a category of people is dangerous, I don't think, you know.
See, that's the point I'm not quite understanding, because Hunt does take into consideration that we don't look felony by felony. And there are, in the Fourth Circuit, non-violent felonies for which you can be deprived possession of a gun.
Sure, so Hunt.
So the whole dangerousness doesn't come into play in Hunt under 922G. I realize we're under not an end, but it seems I don't see the difference, so why we should do differently.
So it doesn't come into play on the individual level, it does at the level of the category. Hunt says Congress, at least in some circumstances, can determine or judge a category of people to be dangerous and disarm them all. And I'm saying there has to be some scrutiny of whether a group actually is dangerous. I mean, if Congress passed a law saying, redheads are dangerous and therefore they can't possess firearms, I hope and assume this court would not simply defer to that and take it at face value.
The point is, agreed, not all felon indictees are dangerous, but neither are all felons.
Sure.
That's the point, it's the same situation. In other words, you pointed to the consideration of dangerousness in the indictment context, but we don't even use it in the context of a felon. It doesn't have to be dangerous in order for 922G to apply to it under Hunt.
Sure, but
so that's the point. Why is it different with 922N?
So I think the difference is in 922G1, this court was, in some sense, deeming it reasonable for Congress to say that felons as a group are dangerous. And my point is, we can't just assume that every time Congress deems a group reasonable, dangerous, that's reasonable. And Hunt points to sort of two limitations on how that dangerousness principle might be, cabined. One is Hunt relies in substantial part on the fact that the Supreme Court has repeatedly said that felon disarmament laws are presumptively lawful. The Supreme Court has never said anything about laws disarming indictees. The second is, Hunt, if you look at the statutes, the historical analogs on which the dangerousness category is based, it's talking about people who, a particular kind of danger. So it talks about groups that I think can be categorized as either disloyal groups, which in Hunt was British loyalists, Native Americans, and religious minorities, or lawbreakers, like felons who have been convicted of a felony. Those are the kinds of groups that underlie the dangerousness category. And I don't think indictees fit in either of those. They're not disloyal. I don't think anyone claims that. And they're not lawbreaking in the same way that felons are, for all the reasons I mentioned earlier. It's simply an accusation that relies on a non-adversarial process with a non-unanimous vote with an extremely low burden of proof, where the government can introduce irrelevant evidence, evidence that would be excluded under the exclusionary rule, et cetera. And so there's not a basis for deeming those people to be lawbreakers in the same way that there is for felons. Hunt, it says several times, that there's a historical tradition of regulating non-law-abiding persons when it's explaining dangerousness. It says that a risk of dangerousness readily attaches to people who have already been found guilty of having broken the law. So it may be reasonable to assume that felons who have been convicted fall in that category, but I don't think it's reasonable to make the same blanket assumption about people who have merely been indicted. That's inconsistent, I think, with the presumption of innocence, as the Ninth Circuit said in Perez-Garcia. Even the Sixth Circuit in Gore, which rejected a facial challenge to the statute, said at step one that it's inconsistent with the presumption of innocence to categorically deem indictees to be non-law-abiding and therefore outside the scope of the Second Amendment.
Well, there's the action of the prosecutor here, too. The ham sandwich analogy is interesting, but ultimately it's the prosecutor that makes this determination, and the prosecutor makes a determination that, well, I can get a conviction on you for a crime that you could be put in jail for more than a year. And that would seem to indicate there's some indicia of dangerousness to it. I mean, you can actually convict of it. And I guess you would agree if he was actually convicted of it and he's possessing it, then of the crime here, beyond the indictment, your problem is it's only at the indictment stage or the charging stage, and it's not at a conviction, and there should be a distinction between being indicted as opposed to being convicted. Is that the basis here?
Correct, Your Honor. Yes, under Hunt, if he had been convicted, obviously he could be disarmed.
Does anybody agree with you?
There are a number of district courts that have held 922N as unconstitutional. The McDaniel case from Wisconsin, which I cite in the reply briefs.
Give me a circuit court case, because district court cases are nice, but we don't know how long they would last.
So there have only been two that I'm aware of, two circuit cases addressing 922N. They both held the statute was facially constitutional. They did not address as-applied challenges. And in fact, they both leave open the possibility that as-applied challenges could succeed. In fact, in the Quiroz case, which is the Fifth Circuit's case, the challenge is, strictly speaking, facial, but there's a part of the opinion toward the end where they do a sort of quasi-as-applied analysis, and they note that the defendant in that case, his underlying felony was burglary. And they rely on the tradition of detaining people pre-trial, and they note at the time of the founding, burglary was a capital crime in most states, or it was a non-bailable crime in most states, and therefore, it's likely that Quiroz himself would have been detained pre-trial in 1791. And the clear implication there, it's again, they don't say it expressly, but the implication is if someone were indicted for a crime that was not capital or analogous to a capital crime at the founding, then that tradition of pretrial detention would not apply to that person, and 922N would be unconstitutional. I see I'm over my time, so unless the court has questions, I'll save my time for rebuttal.
Thank you, Mr. Macbeth.
Thank you.
Mr. Mettinger?
May it please the court, Your Honors, my name is Jason Mettinger. I'm here on behalf of the United States. Your Honors, 922N is constitutional. It's constitutional facially, but it's also constitutional as it was applied to Mr. Jackson here. It's constitutional because it's consistent with this nation's historical tradition of firearm regulation, which has been confirmed by both the Fifth and the Sixth Circuit in recent decisions. Additionally, as we set forth in our briefs, we respectfully submit that the text of the Second Amendment doesn't even reach the as-applied challenge that Mr. Jackson is raising here. So for either or both of those reasons, we respectfully ask this court to affirm. I'd like to start, if I could, with Bruin Step 2. And the reason I'm doing that is because that's where Gore and Quiros went, and those are the Fifth and Sixth Circuit decisions. And so I think if we start there, we look at historical analogs, and we've identified 3 strands of historical firearm regulation that match up here.
Mr. Mettinger, before we get to that, so with respect to the as-applied challenge, the district court in this case, it seemed to be almost an afterthought at the very end of the opinion as to the merits of that claim. And I wonder why we wouldn't simply, if we thought that there was a concern with respect to fact-finding as applied to Mr. Jackson, why we wouldn't simply send this back and ask the court to find some facts that would support the ruling in this case.
Right, so we respectfully submit that the court doesn't have to do that for a variety of reasons. I think the first one is the Hunt decision. That's what, Judge Wynn was discussing earlier. In 922G1, this court found we are not going to go felony by felony in an as-applied context to determine constitutionality. I can't see why 922N would be any different. I know Hunt came out after the briefing, or our brief came in, so we didn't get a chance to flesh this out. But again, I don't see why we would
the difference is that
do.
we're talking about an indictment versus a felony. You don't think that's legally significant?
I actually don't, for purposes of this argument. And again, we have to go back to the historical tradition. And so if we look at the historical tradition of what it meant to be a grand jury indictee, that actually meant something at the founding. So, if you look at the Gore case, they looked at the famous Aaron Burr decision. And there was this clear divide between a complaint, yes, maybe Mr. Burr was bailable, but after that, Chief Justice Marshall said, no, I doubt very much I have that power. So clearly there's this separation when you have a grand jury indictment. You get, as Judge Wynn was saying, this idea of dangerousness, and we have more than just a magistrate.
What it means to be an indictee is that you're innocent until proven guilty. So I don't understand how there's this just presumption that he's dangerous, and particularly in this case, this goes back to sort of why shouldn't the district court do some fact-finding here, because particularly in this case, the thing that made him an indictee in federal court was dismissed in a few weeks after the federal indictment.
So you're just, factually, I'll say, yes, it was dismissed. Later, they rebrought other charges, which he pled guilty to.
That don't have anything to do with his firearm.
Understood, Your Honor. And so, again, I think we can leave those to the side. So we have to freeze frame what it was like at the time that he was transporting this firearm, so he was under a felony indictment. That's what we have to assume. I don't think we have to go back to fact-finding. It gets to the second point.
Was it a felony indictment? For some reason, I thought it was a misdemeanor, but go ahead.
He pled to a misdemeanor later, but yes, he was indicted for the felony, Your Honor. And so what we have to do is look at what would happen in 1791. And this gets to the second point I was trying to make with Judge Diaz about why I don't think fact-finding matters here, frankly. What we know is that he was a felony indictee. And so we have to go back to 1791 and ask ourselves, what would happen to a felony indictee at that time period? And you look at what Gore says and Quiros says, it would have been pretrial detention. He would have been completely disarmed for that entire period. And so if that is the case, the lesser burden of 922N has to be...
He wasn't disarmed here. I mean, 2 separate judges released him on his own recognizance and did not put any limitation on whether he could have a firearm. So even the fact... Go ahead.
So you're 100% right, Your Honor, in the sense that in 2022, judges didn't disarm him. I'll say as a footnote in the...
Lots of things happened in 1791 that we don't want to happen today.
So you're 100% right. However, if we're looking at constitutionality, we have to put ourselves back in 1791. And that's why, if you look at the Gore and Quiros defendants, both of those defendants were released pre-trial too. And yet, what those courts did is said, what Bruin requires us to do is to look at...
Is that only for the Second Amendment that we look at 1791?
Well, under originalism, there's a number of constitutional rights that we look at 1791. But again, applying Bruin, we have to say, what would the historical tradition have been in 1791? If you're accused of a felony, the uniform practice, that's the quote from Gore, the uniform practice is pretrial detention. And so if we send it back to the district court, she's going to say, okay, the uniform practice was pretrial detention. That meant disarmament. And so here in 922N, which is a lot lesser than complete and total disarmament, we're just charging him for transporting across state lines. There is no way he would be released.
So we're at step 2 of Bruin in terms of where you're going now. And at least in my view, it looks like a great big fiction that we've been put on us to go back and try to figure out what they did back in 1791 or anywhere else, but that is the law. That's what the Supreme Court has told us to do. And I think the direction you've taken, there is a presumption of innocence, but that presumption of innocence existed then, I guess, at that time. But felony was different then. I mean, felony was a much more serious thing back then. But nonetheless, you could be detained, could be removed of your gun rights, which could have happened here. The fact that you did not, how does that influence the as-applied analysis if, in fact, while the historical analysis says these things could have been done, even now it could be done, if, in fact, the judge does not do that? If, in fact, if the judge makes a statement, what if in the indictment says, you are not a dangerous person, so I'm going to let you go? Would that influence the analysis here?
I don't think it does, Your Honor. If you look at the Bruin test, it requires us, again, to do this, let's assume we're all judges in 1791, what would happen?
Well, I wouldn't have been a judge in 1791.
Understood, Your Honor. And so I think, this is the test that we have to apply. And again, both the defendants in Gore and Quiros were both released. I mean, so they were modern-day bailable persons. I'll note the defendant in Gore, just getting into as applied, actually had firearms offenses. Those were his qualifying predicates, which is exactly what Mr. Jackson had here. And so, if pretrial detention is the rule, then the lesser burden fits within that historical tradition. It's the lesser.
Do we really even have an as-applied analysis when we use the Hunt method, which looks like to me it's really a categorical determination, and once you do that, if you fit in that categorically, the as-applied nature of it doesn't apply, at least under 922G. So the question is, do we do likewise within?
Right, and Your Honor, my response is, I don't see how one could say 922N, we're going to go felony by felony and use all these as-applied challenges. It doesn't make sense. What the court found in Hunt was Congress categorically can say these are dangerous groups. That's actually consistent with what the Supreme Court has said too.
Except for Hunt. It would make sense, at least in my mind, but I think Hunt has basically gone there and says we don't do this by felony. Now, this is indictment by indictment, but when you look at the two, if you're parsing out the term dangerousness and violence, well, felonies can be both violent and nonviolent. It can be dangerous and non-dangerous. So Hunt folds all that in.
Yep.
But in terms of whether it makes sense, yeah, it does. But I think Hunt leads us differently on that, and we have to follow Hunt.
I think that's right. I mean, I think this panel is obviously bound by Hunt. And again, I just don't know how.
And Hunt forecloses the as-applied challenge here, is your argument.
Yes, Your Honor.
You have to make a facial challenge, or somebody would have to make a facial challenge to this statute.
That's correct. And again, going back to the Hunt analysis and why it got there, it realized we can categorically say, Congress can categorically say, these individuals are dangerous. And obviously they did it in 922G1. They did the same thing in 922N. It's part of the same statutory scheme. And so if we recognize they can do it in G1, how can we not recognize that they can do it in N? And again, all of that is within the tradition, the historical tradition of categorically excluding certain groups from firearm possession. And I will just note, here, if it's allowed in Hunt, Hunt is a complete and total bar. You're a felon, you can no longer have guns forever.
It seems clear to me that this defendant here, not that knowledge is something you have to have, had no knowledge, had no understanding that if he had that gun in that capacity, he could be found guilty on this statute. The way he openly just says, I have it here, and disclosed it, and maybe that's why the sentence is what it is, but I don't know what that means in the long run, but it seems something, most things you can kind of know. If you know you're a felon, it's pretty well known you can't have a gun. I mean, that's pretty much, but the fact that you've been indicted in another state and no gun restriction put on you, and you can go and do what you please, and you just come here, and when you stopped on something else that has nothing to do with the gun, and he says, well, you got anything? He says, yeah, I got a gun over there. Well, he didn't have to say that. Maybe they would eventually gotten it or whatever, but I doubt it, because they basically told him to go home. It seems like something here that doesn't seem quite right, but the law may drive us in the direction that you're pointing us to.
Yeah, I think it does, Your Honor, and I'll say like that, the piece that you were talking about, sort of knowledge of the law and things like that, I think that goes to the substantive elements of intent, and here he conditionally pled guilty to everything, including his intent and knowledge of the law. The only thing he reserved conditionally was this constitutional challenge. So I don't think his knowledge of the law comes into play for what we're trying to decide here.
Not sure it would matter even if it
That's right,
terms of this.
because ignorance wouldn't be a defense here. He has to know the law. And again, I want to go back to what we are actually proscribing here. It's really not possession. We were proscribing transportation. And so again, we have to look at, was there a Second Amendment right, an unfettered Second Amendment right to cross state lines unfettered with firearms? And as we've set forth in our briefs, that was not the case. There is a number of colonial statutes which said you can't export things outside of the colony. And that applied to firearms, it applied to gunpowder, it applied to all sorts of things. So this idea of transporting across state lines, that's, on Bruin step one, if I could go there for a moment, that's what the defendant, his burden has to be. That in the colonial era, he had an unfettered right to go colony to colony transporting guns as he pleased. And there's absolutely zero support for that. In fact, we've proved the negative, in my view, in our brief, because there's a number of colonial statutes which say you can't do that. And so, to even trigger the text of the Second Amendment, he has to show he has this right to transport, and it's just not there. So that's another basis on which this court could affirm, again, without having to do anything else with regard to the as-applied challenge. I wanted just to mention a couple brief comments in response to my colleagues' discussions. We've mentioned this a bit, but my colleague was mentioning a lot about the quote-unquote unreliability of grand juries. I do respectfully part company with him on that. I do think grand juries matter, and that does mean something, certainly, for this analysis here. Again, that's what the founders believed, and it makes a difference. When you're a grand jury indictee, you're going to go to pretrial confinement. There was some discussion about, in the briefs at least, about individualized findings, and we respectfully submit that there didn't have to be individualized findings. You can make a categorical determination here. That's what Rahimi said. You can do that without having an individual finding of dangerousness in this case, and this is what the court said in Hunt as well. We can have categorical bars, and that is completely okay. The other thing I wanted to mention was...
Well, let me ask you about that, because, so Rahimi was a step 2 Bruin case, right, not step 1?
Correct.
Okay. And so Hunt concludes, based on the continued use or language in Supreme Court cases that presumptively warrants or sanctions the disarmament of felons, that suggests, according to the Hunt opinion, that we don't even get to step 2. It's just not within the category of law-abiding people to whom firearms should be allowed to be kept or used in whatever fashion. But the Supreme Court has never said anything explicitly about indictees, right? So why do we assume that we're at step 1 and not step 2 of the analysis?
So our step 1 argument, the government's step 1 argument, to be clear, is focused entirely on the transportation part. So we have actually not made a whether he's part of the people or not argument. That's an argument we're not making. So, what he has to prove on step 1 under our argument is a right to transport across state lines. Is that coextensive with the right to keep and bear? And what we've said is no, it's not. Keeping and bearing, under what Bruin said, Heller said, it's to keep on their person or in their pocket to be ready for offensive or defensive action. And here, what's being proscribed is transport. He transported a gun in a vehicle across state lines. And if he stayed in Arizona, he could have kept in his possession for offensive or defensive action all the firearms that he had previously had in his possession. He couldn't get a new one, which he did here, but all of the ones that he had in his possession, he could have kept and used. What's being proscribed here is the transport. And you know, again, if you look back to the founding era, that was not part of the right of keeping and bearing. You didn't have the unfettered right to go from Georgia to Massachusetts carrying guns. There was a lot of laws that said actually you can't. And so that's really what we focus on Bruin step one, is the transport, and that does not, it's not coextensive with keeping and bearing.
What's the principal reason for restricting the transportation of it? I mean, you do have this right to be armed for self-defense, as long as you say in that Arizona, but the principal reason for a nonviolent felony indictee to not be able to transfer.
Right, so if you look at the law review articles and historical sites and some of the case law on this, they talk about the fact that you didn't have the right to transport. The why of that was for a number of reasons. One, to protect the safety of the colony. So in other words, you couldn't export guns away. We want to keep them here in state so that we can use them in case the British come back. Additionally, there was this concern about if guns go abroad, they might get into the wrong hands. And the wrong hands back in those times were, you know, Indian groups, folks that were deemed to be disloyal to the crown, things of that nature. And so it was sort of this same public safety belief that we have here, this idea that, you know, interstate highways are channels of interstate commerce. We don't want people that are deemed to be dangerous to be traveling in interstate commerce with a gun. And so this, again, 922N is a very, very limited criminal proscription that's in line with this historical tradition, which says you can't go from Georgia colony to Massachusetts Bay colony while transporting a firearm. So there's just a number of analogs that show 922N is perfectly within the sticks of what was allowed in 1791, and in fact is quite lesser of a burden than what would have been allowed in 1791. And if we get there, if we know that this is a lesser burden that could have been imposed back in 1791, this has to be constitutional. And so that's where the government gets to its argument to ask that we respectfully affirm. So, Your Honors, I think the court has heard our arguments. Unless there's anything further, I'll cede the rest of my time.
Thank you, Mr. Mettinger.
Thank you, Your Honor.
Mr. Macbeth?
Thank you, Your Honor. A couple points. First, going back to Hunt and this idea of categorical disarmaments. Certainly, Hunt does say that in some circumstances, Congress can make a categorical judgment that a group is dangerous, even if not every individual is. But again, there has to be a limit to that principle. Otherwise, Congress could disarm everyone. It could say redheads can't have guns, left-handed people can't have guns, people who wear hats can't have guns. And if courts are just meant to defer to that without any scrutiny and accept at face value Congress's judgments, then Congress has exactly the regulatory blank check that Bruin says legislatures are not supposed to have. So there must be some determination of whether it's actually reasonable to deem that group dangerous as a whole. And for all the reasons I've said, I don't think there's a basis for that as to indictees.
Make that clear to me, what the connection. You have indictees, redheads. There's no basis in law. I know that you can simply be detained because you have a redhead, or you can have a gun, take a restriction, but if you are an indictee, you can. I mean, so it seems like the categories, I get your point, that you seem not to have a limiting principle. We're talking about the indictees, again, which has that temporal, that it can be a temporary situation. At some point in time, it's either going to be convicted or not, or you could be detained, you could be restricted, but that's not true with redheads.
So on the detention point, Your Honor, I think for the reasons that are in my brief, I think detention, pretrial detention is just completely irrelevant to people who were not detained. Back in 1791, when people were detained and their guns were taken away, the reason for that was that you can't run a jail if the inmates have guns. So the safe and orderly operation of a jail requires taking guns away from inmates. But that rationale just has nothing to say about people who are not actually detained. And Mr. Jackson was not actually detained. So the fact that he could have been detained if he had, or disarmed if he had been detained is just irrelevant. It's speaking to a category of people that Mr. Jackson does not fall into. The government, also said a minute ago essentially that if you were indicted at the founding, then you were detained, as sort of a blanket rule. That is not accurate. So it is true that in some jurisdictions, if you were indicted for a capital crime, you were presumptively detained. But contrary to what the government is suggesting, it's not the case that all or even most felonies were capital at the founding. And we talk about this in our brief. That's a misconception. There were many, many felonies at the founding that were not capital. And for those people, an indictment did not mean that you were detained. So at most, what that analogy establishes is that 922N is facially constitutional because some people who committed capital crimes were detained, and those people today could be disarmed. And that is all that Gore and Quiroz say. They don't address as-applied challenges. And so if the government is going to say that that analog applies here, they would have to show that Mr. Jackson's underlying felonies either were capital in 1791 or at least are analogous to crimes that were capital in 1791. And the government has not even tried to make that showing. Finally, on the step, I'm sorry, do you have a question?
No, I don't.
Okay. On the step one question, we addressed the laws the government cites in our reply brief. The how and the why of those laws are very different from 922Ns. As to the how, those laws were commercial regulations. They prohibited selling or giving away guns to groups outside the polity. They did not restrict the individual right to self-defense of anyone who was subject to those laws. That is entirely different from 922N, which prevents the people subject to the law from exercising self-defense with a firearm. And the why was very different as well. As Mr. Mettinger just acknowledged, the purpose of those laws was to ensure that there were enough guns in the polity. It was to make sure guns stayed with the people and didn't get sent away where people who were not members of the political community could get them. So very different from 922N, which is meant to restrict the right to bear arms of people within the polity. And unless the court has any more questions, I will stop there.
Thank you, Ms. Macbeth.
Thank you, Your Honor.
I want to thank both of you for your excellent arguments. I will note that, Mr. Macbeth, when you suggested that Congress could disarm redheads, I have a redhead extern in my chambers, and she was shaking her head vigorously no. We'll come down and greet counsel and take a recess before moving on to our third case.
This honorable court will take a brief recess.
Final case this morning, 24-1725, ER versus, I always forget, is it Beaufort or Buford?
I'm not sure, Your Honor. I think it's Beaufort.
Beaufort.
I stand corrected already.
Yeah.
Beaufort is North Carolina. You're
Yeah,
right.
Beaufort County School District. Mr. Willett?
May it please the Court, Sean Willett for the appellant ER. No one disputes that ER's Title IX claim would be timely if the defendant were a private school. The decision below is the only reported case I've seen to apply a shorter statute of limitations to a federal civil rights claim because the defendant is a government entity. That's inconsistent with the plain text of federal law, and it's inconsistent with Supreme Court precedent. I want to start with the text. An amendment to Title IX provides that Title IX's remedies must be available to the same extent against public entities as they are against private ones.
I just have to go and ask you this. Okay, you apply the personal injury statute, which is 3 years. What does that mean? If you apply the statute for 3 years, then what does that mean for your client?
It means our client's claim is timely. There's no dispute about that from the other side.
He can file it by what age?
By age 21, Your Honor.
Because you're adding 3 plus the 18.
That's correct. There's no dispute that you'd add 3 plus the 18.
So why, no, none of you even bring it up. And I don't quite understand. I look at that statute, it says you got a year after the age for majority.
Well, so
But the South Carolina Supreme Court has kind of bounced back and forth on this thing. I mean, there've been cases in which, there's a recent case in which it did just what you just said regarding, it was a different type of offense, but it had a 6-year statute of limitation, but they applied it for the time period, and still that 1 year. I'm just curious. I didn't really want to ask the question because no one brought it up, and I figure you guys know South Carolina law better than I do, but.
well, I agree, Your Honor.
So we are in agreement here that if that applies, then you have 3 years from the age of majority. You're not limited to the 1.
There's no disagreement from that on the other side, either below
So
or here.
They didn't brief it. There's nothing there either.
Right, and I think to the extent there's a lack of clarity, even whether it would apply under state law, is a reason the court shouldn't reach that issue here. I do think that
So it's
this
your
is a
point
federal.
in this case, it's your point in this case that there's no court that's limited itself to the consideration of the state's Tort Claims Act, which has a shorter statute of limitations of 2 years. That these cases have basically used the personal injury statutes for the states that analogous to the federal law.
That's correct, Your Honor. Usually they do use the personal injury statute of limitations. I think 2 more points on the issue of the 1-year cutoff. One is that I think there's the best and most analogous statute of limitations that applies to this case would be the sexual abuse specific statute of limitations in South Carolina, because this court has held that the specific statute of limitations would govern the general one for purposes of selecting a statute of limitations for a federal claim. I think there's one more point to be made about that 1-year cutoff, and that's that there would be 2 steps here. One, does it apply under state law? As Your Honor pointed out, I think that's unclear whether it would apply to minority tolling under state law, because there seem to be decisions in the state court going both ways. The other problem is whether the federal court would adopt that statute, that 1-year cutoff for a federal claim.
But I was more curious that nobody brought it up.
And for that reason, I don't think the court should reach it here. But I think the court can resolve this case by holding that the SCTCA does not apply to ER's Title IX claim for the purpose of the statute of limitations. And there are 2 reasons for that. I want to start with the text of that Civil Rights Remedies Equalization Act. I don't think the other side really disputes our interpretation of the text or how it applies here. They just say we forfeited our right to cite that on appeal. I don't think that's right, because it goes to the very same issue, fundamental issue that ER raised below, which is that the SCTCA is not analogous to Title IX. But even apart from the Equalization Act, the decision below conflicts with Supreme Court precedent, namely the Supreme Court's decision in Burnett v. Groton. That case tells us that when a federal court selects a statute of limitations to apply to a federal civil rights claim from state law, you don't just look at the state law that would apply to a state law claim against the same defendant. You also have to make sure that the policies behind the state statute align with the policies behind the federal statute, in particular that the state statute does not reflect particular state concerns that are, one, inconsistent with the federal statute, or two, of marginal relevance to the federal statute. And in particular, in Burnett, the court held that you can't apply a state statute of limitations that's designed to specially restrict remedies against public entities to a federal statute designed to augment those remedies. And that's exactly the case here. In enacting Title IX, Congress...
Can I ask you about that and related to the early argument you made that with respect to the civil rights statute. So the district court obviously was not made aware of either one of these sort of, you call them nuances on the original argument, but the problem that I have is, you know, we oftentimes criticize district courts and reverse them when necessary, but it seems kind of unfair because you're suggesting that court should be reversed on points that the court simply had no occasion to consider.
Well, I think the court did have occasion to consider the key point here, and that's that whether or not the SCTCA was analogous to Title IX. That's the argument in the brief that ER made below. And I think particularly helpful on this question is Judge Wynn's decision in 68th Street Site Work Group, cited on page 12 of our reply, where you had a pure question of law just like this, whether the Superfund Act included a knowledge requirement. And the appellants cited several statutory provisions on appeal that they didn't cite below and made a new point based on those statutory provisions that they hadn't made below, that certain other provisions of the statute reference a knowledge requirement, and they wanted the court to draw a negative inference that the core provision at issue in that case didn't include a knowledge requirement. That argument wasn't made below, but the court still considered it because it bore on the fundamental question that was presented below.
Did we consider it in order to affirm or to reverse?
I believe it was to reverse, Your Honor. Because I believe yes, it was to reverse because the district court had found that the Superfund Act included a knowledge requirement, and I believe you reversed based on that argument in part. I think another helpful case is the Supreme Court's decision in Yee v. City of Escondido, where below the appellants had just argued that they argued a takings claim, and below they just argued a physical taking. On appeal, the Supreme Court considered an argument of a regulatory taking because it bore in the same fundamental question. So I do think that the act is properly before the court, but even if it weren't, I think you still have the clash between...
How would you articulate the same fundamental question that was before the district court and that's before us? So that they would fall within the cases that you're talking about.
Right. I think the fundamental question here is whether the SCTCA is analogous to Title IX, such that it's appropriate to borrow its limitations period. And I think helpful on framing this question is the Supreme Court's decision in Burnett, because that's how the court framed it in Burnett. What the court held there is that the statutes were not analogous because the goals between those statutes clashed. There was a particularly short state statute of limitations that applied only to claims against the government as a public employer, and the court held that that clashed with the goals of the Federal Civil Rights Act 1983, because 1983 was designed to augment remedies against those same defendants. And that's particularly the case under Title IX as well, because Congress made a policy decision to create a remedy against both public and private schools. In fact, most schools covered by the statute are public schools. The statute specifically calls out public schools within the definition of federal program or activity to which the statute applies. You have a line of Supreme Court decisions that's read the statute broadly and its cause of action broadly to provide effective remedies for victims of discrimination in cases against public schools. And in fact, more recently in Snyder Hill, the Sixth Circuit read Title IX broadly in the statute of limitations context for that reason. It extended the statute of limitations under a federal discovery rule based on the statutory goal to provide broad relief to victims of discrimination. And that goal clashes with the SCTCA because this is a statute that's specifically designed to impose sovereign immunity when the federal statute specifically strips sovereign immunity. It is designed to limit state remedies expressly against state defendants. And for that reason, the goals clash. And at minimum, the statute serves goals of marginal relevance to Title IX, because nowhere in Title IX is there a hint that the statute serves a goal to protect public entities. And so I guess to paraphrase Burnett, because the statute serves that narrower state goal, and because the statute of limitations is abbreviated precisely because of that, that makes it an inappropriate analog from which to borrow, and the court should look elsewhere in state law for the statute of limitations. And here, I do think that the best fit is the sexual abuse statute of limitations. I think that avoids the issue that Your Honor, Judge Wynn raised about the 1-year cutoff. This court has adopted a case-by-case inquiry where it applies the statute of limitations that's more specific to the substance of the case.
Where did we adopt a case-by-case determination for Title IX type situations?
The decisions
No other
in...
circuit has done that.
This circuit has. It started with a decision in Wolfsky, which I believe was a Rehabilitation Act case, and the cases that we cite about the Rehabilitation Act are relevant to the Title IX claim because courts generally interpret those statutes in parallel because they're all spending clause statutes, and in fact, they're grouped under the Equalization Act.
But hasn't the Supreme Court said that where state law provides multiple statutes of limitations for personal injury actions, that we should borrow the general statute?
I think
as
those...
opposed to what you're arguing about the sexual abuse statute?
I do think that those cases are distinguishable, and I believe this court has decided recent cases. Well, so I think the Supreme Court decided that in Wilson in a case called Reed, which I believe was back in the 80s or 90s. And this court has continued until, up to very recently to apply a case-by-case determination in the Title IX context. I think that a particularly helpful case on this is, although it's a district court case, it's the Northern District of Ohio's case in Doe v. Cleveland Metropolitan School District.
It's a court case not even in our circuit.
But it provides, I think, well, okay, to go back to the circuit case law, though, this court has applied a case-by-case determination to Title IX claims. In the Moore case, you had an employment claim, and the court applied the employment statute of limitations to that Title IX claim, the employment discrimination statute of limitations.
Are you within the statute of limitations regardless, whether it's the general liability or the
sexual abuse statute of limitations? Yes, Your Honor. And to complete my answer to that question, in Wilmink, the court applied a different statute of limitations to a student's claim for sexual misconduct, even though the court had previously applied the employment-specific statute of limitations. And in Your Honor's decision in Seminova, you discussed this, how the court applies different statutes of limitations to the same statute depending on what the specific claim is. And you discussed how in a Rehabilitation Act context in the employment context, the court applies a different statute of limitations than it does for a Rehabilitation Act claim in the public accommodations context. So it is something that this court does, and I think it would be inconsistent with this court's case law that applies more specific statutes of limitations to employment claims to say we're just going to adopt one statute of limitations when it's a sexual abuse claim. And with that, I'll save the rest of my time unless there are further questions.
Thank you very much. Mr. Brown?
Thank you, Your Honor, and Your Honors, and may it please the court. My name is Stephen Brown. I'm here on behalf of the Buford County School District. Just to clear up, and if I talk too fast, slow me down. I'm used to 10 minutes with our Supreme Court in South Carolina, so I've learned how to regurgitate a little too quickly. It is conceded, it was conceded in front of the trial judge, that if you come under the general statute of limitations in South Carolina or the sexual abuse statute of limitations, ER's claim is timely. The judge found, however, that neither one of those was the most analogous state statute of limitations. Instead, it was the South Carolina Tort Claims Act, which is a 2-year statute of limitation. And I apologize, I get a little...
Say that again. You said it was conceded what? That
the general, if you look in Judge Norton's order and on the transcript, under the general statute of limitations of just 3 years, don't get into the, as someone said, the Supreme Court of South Carolina hip-hops or whatever, and that's very agreed.
That.
Yes, sir. But under that under that statute, or sexual abuse, the claim would be timely filed. I think under the general within a week or so.
So that the issue about the 1 year is not
No,
really
sir, that's not in
before us.
place, so that's why nobody briefed it. That's, I understand your question, but that's,
Conceded. So the end
that
of
never
that.
got there. No, sir, no one was
So you
taken
were saying
that.
that if we do in fact apply that general statute, which is a personal injury one, for 3 years, then that's timely.
Yes, sir.
But you are here to argue that because it's a governmental entity, we should go under the state, the Tort Claims Act.
Not per se that it's a governmental entity, but the most analogous statute of limitations under the facts. And counsel is correct. This circuit has been somewhat unique compared to other circuits.
But you couldn't use the Tort Claims Act against anybody other than a governmental entity. I mean, you wouldn't get an analogy if she brought it against someone else.
No,
So I mean, that's why I say it's a governmental entity. It's crucial here.
It is a governmental entity, and that
Yeah.
is crucial. And so what the trial judge did was sit there and to take the claims that were out there. They had brought original claims that they dismissed under the Tort Claims Act, and then they had a Title IX claim. And the judge said, let's look at what the allegations of the Title IX claims are. They essentially come down to the most analogous cause of action would be negligent supervision, and a negligent supervision claim under these facts as presented, which would be against the Buford County School District, which he is looking to its governmental status. I
So you
understand and
think we
agree.
should do a case-by-case analysis?
I think that is the standard this circuit has previously set, is that unlike many circuits, it's very
I
case-specific.
mean, unlike any other.
Well,
There's no other circuit that does that, is it?
not to my knowledge, Your Honor, that I could find in my research. However, that language that's been used, and the counsel pointed out, is used throughout numerous cases in this Fourth Circuit. So it's not like one panel decided they were gonna,
So why doesn't Wilson tie us? I mean, it admittedly it deals with Section 1983. The Supreme Court said, we don't do case-by-case approach on that. We always use the state's personal injury statute of limitations.
and you know, Your Honor, well, first of all, it is 1983, and 1983 is different than Title IX because Title IX created new causes of action. 1983 gave people rights to pursue constitutional violations. But in looking at Wilson, my general reading of it, and when you read cases that followed Wilson, was that it established, I thought, almost a per se rule, was just the way I took it, that you go with the general personal injury statute of limitations. But when,
Not to argue with it, but I mean, if you took this case-by-case basis, there's a South Carolina statute that's almost on all fours on this sexual abuse that has a 6-year statute of limitations. If you did it case-by-case way instead of the general approach, looks a lot more analogous to me than the State Tort Claims Act.
I think, Your Honor, if you go and look in South Carolina, the cases that have been decided, and they're in our brief, I think it's State, Duncan, City of Duncan, also City of Greenville, they address this, how do you go back and forth with the sexual abuse statute and the Tort Claims Act statute? And they go with the Tort Claims Act every time, Your Honor. The sexual abuse statute, and Amicus filed a brief on this, and the brief is more on the principles of supporting victims of sexual abuse, and no one is opposed. I mean, we understand sexual abuse is a substantial problem. So that being as it is, getting back to the question on Wilson, if you look at cases that follow Wilson, it's generally the general statute of limitations. But there are cases where courts look at particular facts. Now, those are district court cases, Your Honors, and but Wilson is not binding on this. I think counsel is correct. There's not a Title IX case out there that addresses this that we can find on the Tort Claims Act. There was the case out
But
of,
the South Carolina Tort Claims Act, the section of it that provides for the statute of limitation states that it applies to any action brought pursuant to this chapter. So is this action brought pursuant to the South Carolina Tort Claims Act?
it's not brought pursuant to the Tort Claims Act, but the court made very clear in its order, it said counsel is hung up, counsel for the appellant, is hung up on this issue that this cannot be a Tort Claims Act case, that this is not a Tort Claims Act case. The trial judge said, I understand that, but I'm trying to come up with the most analogous state court statute of limitations. So he wasn't saying it's a Tort Claims Act. If you look at, I'm sure you have looked at it, but in his order, he's very clear on why he's getting where he's getting.
Well, appellant, I think, also argues that not only was it not brought under the Tort Claims Act, but it would not be cognizable under the Tort Claims Act, and for that reason, that statute of limitations doesn't apply.
I believe the negligent supervision is what the judge made it determine was most analogous. And I believe that claims for some of the violations as set forth, and there are very broad violations in this complaint, would be. But again, I think that's a bit of a red herring. I think the question is just simply, what is the most analogous statute of limitations? And what we haven't, you raised the issue. This is something that nobody briefed, but you know, when you sit in a hotel room for 2 nights getting ready for something, fear is a good motivator, and you go through. The Equalization Act talks about remedies, that you have to make sure the remedies are the same. Statute of limitation, at least as I was taught in school, is not a remedy. A remedy is the outcome of what you're seeking in a lawsuit, be it money, be it equitable relief, be it declaratory relief, be it whatever relief a court deems just and proper. So having a statute.
The Tort Claims Act to say a Monell claim under Section 1983 is dealing with a supervision, almost on point what you're talking about. Looks like to me that's a case that you would, if to follow you, you wouldn't follow Wilson, which says no, you do it. Wilson says those cases, if you look at a personal injury, but the most analogous statement to that type of case surely looks like to me it's a State Tort Claims Act statute of limitation.
I think, Your Honor, when you go back to Wilson, you have to remember that was 1983, and we have to recognize that there, although we tend to sort of group everything together, there are differences between 1983
Well,
actions
that's
and
my
Title
question.
IX.
If it was a 1983 case, and it was a Monell claim, for instance, or a claim against a governmental entity, following your logic, you need to look at the State Tort Claims Act, not the personal injury. I mean, it would apply for that. I'm just saying, if that logic follows that this is most analogous, this situation of sexual abuse is most analogous to the type of claims you would bring on the State Tort Claims Act, it would seem to me you would bring a Section 1983 type action could implicate the same kind of concerns that you would seek to recover from. Particularly, and I use Monell because that's one of the instances which you can get the cities and others in because of what the negligent hiring or whatever that gives liability under Section 1983.
And I understand what Your Honor is saying there. I don't know that I'm going to concede that I would go ahead and argue the Tort Claims Act there or that it would be personal injury. I think I'd have to see exactly what it was.
Well,
but
you don't have to. Wilson says that's what it is.
Well,
Wilson tells
us what to do with 1983 actions.
That claim right there is a Section 1983. It says we don't
Wilson
do this
tells
case.
us.
We just
Exactly.
do personal injury. So
Wilson tells us.
But it doesn't follow under your logic why that would be so, because that surely fits better on the State Tort Claims Act than this sexual abuse one does. That's my only point. I'm just saying it looks like to me.
I understand that,
doesn't
and I
seem
get back
make
to the issue, Your Honor,
any
of
logical sense.
the judgment, with all respect, that Title IX claims are different than 1983. You look at the specifics of it, and as my time gets down, I would like to make this point because I do think it's an important point. The Civil Rights Remedy Equalization Act, 42 U.S.C. 2000 D7 A2. And I'm going to just call that A2 if y'all don't mind, because I'm a little dyslexic with numbers and it'll just start jumbling and make for a horrible record, etc. Section A2 was never brought up in opposition to the motion to dismiss for the statute of limitations. The motion was based upon the applicability of the South Carolina Tort Claims Act and the argument that the Sexual Abuse Act doesn't apply, and the general does not apply, that you go with the Tort Claims Act under this case. The district court held a hearing. We've made sure the transcript was put into the supplemental appendix, not raised one time. You will not find it there. No motion to reconsider was filed. The first reference you get to the Equalization Act and this argument that the remedies are somehow different and therefore you can't go with the Tort Claims Act statute of limitation is in the opening brief to this court. Now, I recognize this court has the discretion to address issues that come before it, but this court has said, and if you'll allow me to dig in my notes for just a second, that although it's within your discretion under those circumstances where issue has not been raised at all until it's on appeal, it should be done sparingly and under the most exceptional of circumstances. And so then I think this court, to get to the actual issue, before you even get to the merits of it, has to act the fact, is this fundamental error? Did the ruling of the trial court and the fact that they don't raise it until their opening brief, does that constitute fundamental error? And my reading of this court's case law is, well, we start off by doing the plain error analysis, and then we go a step further. But if you can't get through plain error, you're never going to get to fundamental error. In fact, this court has said that the bar for plain error is much higher than that with regard to, fundamental error is much higher than that with regard to plain error. And the briefing in this case did not even address fundamental error analysis. And this court has, and we cite case law that says if it's not briefed, if you don't brief why you didn't bring it up below, then we can't get to it. And the exceptions are if it's something that is such a...
Is that a forfeiture or is that a waiver?
I think it's a waiver, Your Honor. I think the language that's used is a waiver in the case law.
The result is you don't get to it.
You don't get to it.
If you don't brief something, you don't get to it.
Yes, sir. And I know it's a different circuit, but I thought the 10th Circuit had a rather witty little saying about it. Said we're not the court of second chances and we're not the court of, ooh, I got a new argument for you. And we cite that in a footnote. And I think that that is the case here. I do not believe the sexual abuse statute of limitations, which effectively takes you up to age 27, applies. There are no allegations in this complaint that any school official abused ER in any way. The sexual abuse is not by the school. This is not a case where any school employee, person under their control, etc., committed any act of sexual abuse. The allegations are simply negligent supervision, claims that they didn't respond appropriately to information that's alleged and that we assume for purposes of this motion is true.
The allegations are certainly among some of the worst I've seen in terms of sexual abuse type situation that went on for quite a while with a young female student, culminating in what she said was 2 rapes by a football player that ultimately did not go to trial because I guess she didn't testify. And I don't know what that means, but I mean, it's pretty bad stuff. But here we're just dealing with the statute of limitations on it, so we're not getting into that aspect of it. But it's intriguing to consider. I mean, I don't know whatever happened to the rape charges. I probably don't have a statute of limitation for the criminal charge of rape, so you still can deal with that. But that would be outside of the civil side of where she's pursuing this.
Within the allegations of the complaint, Your Honor, though, I do believe it states that ER refused to give a statement against the alleged rapist. And my understanding is I don't believe charges were made as a result of that. And it also states, I believe in the complaint, that it was much to the chagrin of her mother. Both of her parents worked in the Buford County School District. Her father was an administrator and her mother was a teacher. Whatever happened to ER, I don't dispute, reads horribly in the complaint. And we're just at the complaint stage, so we haven't gotten into the discovery to say what is and is not correct. But here, we're on the question of number 1, is there a waiver? Will this court allow you to wait until your opening brief to come up with a new theory? Because if you look, their theory is it's either sexual abuse statute of limitations or it's the general personal injury statute of limitations, not. And they knew we were moving for Tort Claims Act. They knew that was the basis of our argument. And they did not ever raise, by the way, under Section A2, you can't do this because somehow the remedies would be different at all. That was not, you will not find it in the record until the opening brief.
Can I take you back to the back and forth you had with Judge Wynn about Wilson and the civil rights statutes and 1983 actions, and your response to the questions about why the result here shouldn't, that we shouldn't follow Wilson is that you said Title IX is different. That's what you said.
Yes, sir.
Okay. But that doesn't really help us. So what is it about the difference that makes, that suggests a different result?
In reading the background of Wilson, reading Wilson and all of the case law that's followed from it, it seemed that 1983, there were still efforts going on by maybe certain states to keep bits and pieces of sovereign immunity, et cetera, et cetera. And so Wilson came in to try to say, let's clean this up. Let's have a presumption that it will be the personal injury cause of action. And I do believe it's a presumption. I think it can still be overcome under certain circumstances in Wilson, or at least I've read district court cases where they've done so. Those have not been reversed, so we take them for what they're worth. They're outside this circuit as well. Title IX, Your Honor, and especially in this circuit, in this very circuit, we look very specifically. We don't have the default of Wilson in Title IX.
You say we, it's,
We in this circuit, I'm sorry.
Right.
I don't mean to
but
take
the question is,
ownership.
why shouldn't we? What is it about Title IX that makes it the difference, all the difference in this case, according to you?
Well, because Title IX encompasses, as would 1983, but Title IX encompassed a new claims. It created new claims. And so the district courts, coming up with the proper statute of limitations, wanted, according to Congress and according to all the history of the legislation, et cetera, want to take into consideration very carefully the sort of specifics of the state and its rules and its how it deals with statute of limitations. And that is why the Fourth Circuit says we look very specifically at the facts. We make a factually intensive determination.
Case by case.
Yes, sir. But it also talks about, I think,
don't know of a case that's published that we've said that. What is that case you cited? You tell us.
the
Not a
factually,
published opinion that
factually intensive.
that says we do a case by case analysis. Both of you alluded to it.
I apologize. It's in my brief and it's there. It does exist, I promise.
And it's published.
Yes, sir. I believe it is published. I wouldn't bet my life on it, but I'm 80%.
I don't think I saw anything published in it, but we won't spend time on it because that's easy to determine. But let me also say, it seems to me that you want us to rule against 8 other circuits that specifically address this issue and says you go to the personal injury. And one particular circuit, it might have been the 8th Circuit, said it analogized. It says Title IX is like Title VI. Title VI is very closely aligned with a Section 1983 claim. Walked itself right back into Wilson, just as smooth to show you how it all ties in. And yet you say it's because this circuit has a unique set of cases that say we look case by case, and that's going to turn on whether maybe someone else, maybe I'm just overlooking it. I think the cases you cited are unpublished, but I don't think they're published opinions. And if you don't have published opinions, we don't say that. That might be some guidance we look at. But the end result is the outcome would be to go against 8 other circuits that's gone completely the other way on this.
My time is up, but may I answer that question, Your Honor? I'm not asking you to go against 8 other circuits because 8 other circuits have not addressed a state Tort Claims Act type limitation issue. They have not. They have looked at a variety of other cases, but if you go through the various cases that counsel cites.
You have a case that says that the identity of the defendant can make a difference in a Title IX.
No, sir, and they have no cases that address the Tort Claims Act. I wrote down from counsel.
We would be the first to do that, too.
Yes, sir. There are no cases, according to counsel, there are no cases that have addressed whether the Tort Claims Act provides for a shorter statute of limitations. So I'm not asking you to go against any other sister circuit. I'm asking that you affirm what the district court did, which was to make a thorough analysis of what the most analogous cause of action was. I thank this court for its time.
Thank you, Mr. Brown.
A couple points. Stanley, in the Ninth Circuit, Your Honors, refused to apply a state tort claims act to a Title IX claim and opted to apply the general personal injury statute of limitations.
You have 8 circuits that said Title IX action should borrow from the state's personal injury statute. You got some pretty strong law of the other circuits. The focus here is said we should be different because somewhere there's a case that says we should do it case by case, and you said it, so I'm sure you have a cite to it.
I think the
And
best.
it's published, and it's a published
Published.
opinion. What is it?
I think the best decision to look at is ought. I believe it's cited on page 30 of our opening brief, which discusses in the Rehabilitation Act context how the court has applied different statutes of limitations based on the type of discrimination claim that's alleged, whether it arises in the context of a public accommodations context or an employment context. The court applies different statutes of limitations to the same statute.
So a totally different statute.
It's not a totally different statute. There's a mountain of case law that interprets the Rehabilitation Act's cause of action in parallel with Title IX's cause of action, because they're both spending clause statutes, and they refer to the same remedies. If Your Honor looks at the Supreme Court's decisions, and I think Barnes is one of them.
Well, what I'm looking for is a case that would say we don't follow Wilson, which we kind of have to, I think, is a Supreme Court case. Wilson makes it very clear. These, at least for Section 1983, and when you do the analogous determination, Eighth Circuit did it by saying it looks like a Title VI. Title VI is very closely aligned to Section 1983. There it is.
Both the Rehabilitation Act and Title IX borrow Title VI as remedies. So that's why courts interpret them in parallel. So I think it would be, I'm not quite sure how the court would get around the inconsistency if it reads Title IX differently than the way it's read the Rehabilitation Act in this context. But I do think we still prevail if the court applies the personal injury limitations period. I do want to clear up one thing with respect
Well,
to.
I just heard you prevail because it's conceded. It shouldn't matter to you whether it's personal injury or whether it's the other way.
Correct, it's conceded, Your Honor.
What I
So
understand what the counsel says is that it was conceded at the beginning that if it applies, is it. Why do you need to argue whether it's sexual abuse or not, if that's true?
Right, it doesn't matter for purposes of this appeal.
That was conceded at the beginning of the trial?
That's correct. And I do think it would be helpful to provide guidance on what's the correct statute of limitations here, but.
So it doesn't matter to you?
That's correct, Your Honor. And as to the forfeiture issue, to the extent that the court has any hesitation about forfeiture here, I just want to make clear that the other side has only argued forfeiture with respect to the Equalization Act. That's what you heard here at argument today, and that's the only thing they argued in the brief. So, for example, starting on page 4 of their brief, Appellant raised her argument regarding 42 U.S.C. 2000 D7 for the first time on appeal. Nothing about forfeiting any of the other arguments that we make today. So our argument based on the Supreme Court case law, which is a distinct argument based on Burnett and Felder in the Supreme Court case law, holding that you have to make sure that the purposes behind the federal statute and the state statutes align, and how that there's a clash here. That all applies, and that's properly before the court, and I don't take there to be any dispute about that. I want to address the point that counsel made for the first time at oral argument about how the Equalization Act refers to remedies and a statute of limitations isn't a remedy. It's not our argument that a statute of limitations is a remedy. What we're saying is that however you interpret the word remedies, even if it's just damages or an injunction, those damages or an injunction or your right to sue aren't available to the same extent against public or private schools if you can only pursue those remedies for 2 years against public schools, but you can pursue them for 3 years against private schools. One more thing. My friend on the other side referenced that ER refused to give a statement to the police, and I just wanted to point out that, as alleged in the complaint, that's because one of the school employees she reported to actually pressured her not to complain to the police. Well, that's relevant here, I think, because it speaks to the reason that the South Carolina legislature passed the sexual abuse statute of limitations just for this specific type of case and for those specific types of concerns, because sexual abuse victims often face pressures not to report. You're dealing with trauma and other issues that require more time to file lawsuits, and that dovetails with the purposes of Title IX, and for that reason, I think the court should apply the sexual abuse specific limitations period.
Thank you, Mr. Oh, do you have another question? Thank you, Mr. Willett.
Thank you.
Court thanks counsel for their arguments. We'll come down and greet you and adjourn for the day.
This honorable court stands stands adjourned until tomorrow morning. God save the United States and this honorable court.